Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about a very recent Supreme Court decision, and we're talking United States Supreme Court, not from any particular state. There were splits along the circuits as to how they viewed this, and the Supreme Court ruled actually in the favor of immigrants. And with all the anti-immigration rhetoric going around, with all that Trump is yelling and not to let any of the immigrants in, this was a very good case. So let me just tell you what it was about, how it might affect you, and how it can help you. First, let me tell you procedurally what happens when somebody is put into removal proceedings or deportation. The first thing that happens is they will be issued what's called an NTA, or a notice to appear. And with the notice to appear, there are several different parts to it, and I'll just specify briefly what they are. So the first part would be allegations essentially that you're not a U.S. citizen, and allegations of when you came into the country and so forth. And then the next section will be allegations of why, essentially legally, they want to put you in removal proceedings. What makes you removable? So that might be you committed a crime, or you've just been out of status, or you committed fraud, or whatever the situation is. It'll list the various provisions, and then it will list when your court date is, when you're supposed to go to court. So normally what happens is when you are submitted or issued an NTA, there's what's called the stop time rule, and what that is that stops the time from accruing for you to have different forms of relief. So one is called cancellation of removal. It's a big form of relief that if you qualify for, even though you're put into removal proceedings, you're able to get the green card. And the general rules for cancellation of removal for non-permanent residents are that you've had to be in the U.S. for 10 years, that you have good moral character, and that a U.S. citizen or lawful permanent resident, spouse, or parent will suffer extreme hardship, or a child will suffer extreme hardship if you are deported. So while that's not easy to get, one of the big issues that has occurred is that a lot of times when someone's served with the NTA, they don't have 10 years yet. They might only have 9 years. They might only have 8.5 years, whatever it is. And the second they've been served with the NTA, the time stops, even if their first court hearing is after the 10th year they've been here. So this Supreme Court ruling essentially said that when an NTA is served on a client, respondent, that if the time, date, and place of the court is not set, that it is an insufficient NTA, and therefore the stop time rule does not apply and it continues to accrue. So, for example, if someone is served with an NTA on the 9th year they've been here, and by the time they get to court, it's 10.5 years or whatever, and a lot of times what happens is the NTA itself will say at a time and place specified. As a matter of fact, 95% of NTAs that are served on clients will say time and to be determined, and then later they will get a notification in the mail of when their court is. So the court is just saying that this NTA, which has no real date as to when they're supposed to go to court, doesn't comply with various rules, and therefore time keeps accruing. So how can this help you, people you know, and other people who have even been issued removal orders? Well, well, if you got into court before and you were unable to apply for cancellation because you didn't have the 10 years, you might have the 10 years now, or shortly thereafter you were served, because it didn't comply with what the U.S. Supreme Court is saying. So now you can, on those cases, you can go back into court, do a motion to reopen so that you can be adjudicated for a cancellation of removal. So even if you have already been ordered removed and had the cancellation denied, and maybe it went up to the BIA and the BIA dismissed the case, you're still eligible to file this. And then, of course, for all the new cases, you're eligible. The time continues if it's not properly done. So, of course, immigration is going to have to change the way they issue NTA so that it actually has a date and time set on it so that they don't run afoul of this Supreme Court decision. So that, in a nutshell, is what this new decision is. It's the Pereira case. If you need more information on that, give my office a call. I'll give you the initial consultation's free. If you like the video, click like, subscribe, and more on the coming videos. Thank you.